was handed this document, and we have them on the table. This is apparently on behalf of the creditors committee, the attorneys for the creditors committee. Peter was talking about the creditors committee that represents all the creditors. They have created a form that says creditors joinder and statement of support for transfer of venue to Northern California. Now, I am not anywhere close to a lawyer, but what I think this is there was something like this, you probably read in the paper, there were 66 people that signed the same thing saying transfer the venue to Texas. I think this is the creditors committee wanting to get people to say, actually we want it to be in California. So there are copies on the table over there if you're so moved to sign that. You can do that. There's one for people who are creditors of Scopac, one for people who are creditors of Pacific Lumber, and one for retirees. So check them out over there and you can sign them and we'll make sure they get to the creditors committee attorneys. With that, Peter is still conferring with my lovely assistant Allie, trying to figure out how to address these questions in a most logical order, and here he is. And I want to remind you again that when we finish at 8, Peter will be around to talk to folks one-on-one. Thank you so much for your attention and patience.
So these are a great bunch of questions, very good, very thoughtful. I know the answers to some and not to others, and I'm just going to go through them, and they're not in any order, so they bump back and forth from what we talked about. Do the courts approach unsecured creditors for participation in the creditors committee, or must individuals request to be part of the committee? How often do they meet? To participate, you need to be in Corpus Christi. I had a list of participants on the board, and one of them was the U.S. trustee. That's an officer in the Department of Justice. And very early in the case, they look at the list of creditors that the PALCO has submitted, and they pick the largest, the 10 or 12 largest, and ask them if they want to participate in the committee. Then that person appoints the committee. You can call up the U.S. trustee and offer to be on the committee, but it's up to the U.S. trustee to appoint you. If you're interested in serving on a committee, I believe that the U.S. trustee may consider adding people to the committees. If you have a claim for $100, I'll be frank with you, you're wasting your time. But if you have a big claim, or if you think that your type of claim is a claim that's not represented on the committee, you certainly can call the U.S. trustee, and what you do is you go on the web and find the United States Bankruptcy Court for the Southern District of Texas, which is where it's located, and on that web page there will be a link to the United States Trustee's office. Just call any phone number that shows up. Say, I want to talk to the U.S. trustee about the creditors committee in PALCO. I want to be added to the committee. And who knows? You could be added to the committee. How often do they meet? I don't know the answer because I'm not a member of that committee. But creditors committee, I said the cases can run for a year and a half. Sometimes the committee will meet every month. Sometimes the committee will meet for 3 straight days. So it depends on what's happening. If the committee has good lawyers, they will be in constant contact with you, telling committee members what's going on in the case. To participate, do you need to be in Corpus Christi? No. Most members of the creditors committee are actually residents of California. I think there's one from Nevada, but most members of the committee are in California. The lawyers for the committee are in San Francisco. The financial advisors for the committee are in Los Angeles. And my understanding is the committee has always met in California. If Horowitz's plan is to file and win lawsuits, are the lawsuits part of the plan that creditors and shareholders have to approve? That's an excellent question. And remember, I told you that a company can operate in the ordinary course of business without court approval. But to do anything extraordinary requires court approval after creditors' comment. But my understanding is that filing lawsuits is part of his ordinary course of business. So he probably can just go ahead and do it. But I will tell you that if he was, and to give the guy his due, his lawsuits aren't completely frivolous. They don't just get thrown out on their ear and he gets charged for a double filing fee for filing a frivolous lawsuit. But if he ever did file a completely frivolous lawsuit, and I was representing the creditors committee, I would go into the court and say, Judge, he's wasting everybody's money. That's a waste of time. But probably the answer is no. Unfortunately, he doesn't have to get approval to file lawsuits. When the old Fortuna Mill property and the houses in Scotia sell, where does that money go? Does it help Palcom and Scopac, or does Maxim get the money? One of the there's good things and bad things about bankruptcy, but one of the things I told you about is that the committees and the court scrutinize what the debtor does. And they will investigate past transactions, and they will scrutinize what management does. These are the companies in bankruptcy. And they've got a bunch of creditors that they owe money to. If they sell an asset, that money cannot go up here. That money has to stay here until the creditors are taken care of. So the answer is, that company cannot sell assets and upstream, we call that upstreaming the money to its corporate shareholders, to its corporate parent, without, well, I was going to say without court approval, but no court would approve it. You can't do it. You can't do it. So those assets and the value of those assets will stay with the company until the bankruptcy is resolved. If Palco sold its Fortuna Mill property for $10 million under Chapter 11, would the money go to Maxim or to the creditors? Same question. It would stay in this family of companies, and the treatment of that money would be part of the reorganization plan. So the plan would say, we're going to pay unsecured creditors in full, and what are we going to use? We're going to use the money we made from selling assets, for example. Are assets that Maxim has taken out of the Chapter 11 companies fair game to creditors, or is that money gone? I'm going to give you a short answer. This is a very good question, and it's a complicated question. The answer is that the court will scrutinize transactions between the companies that are in bankruptcy and their non-bankrupt affiliates. So, any money that has gone, so for instance, say, I told you, in bankruptcy, if they sell the mill for $10 million, Maxim can't get it. It's got to stay down here. Suppose they sold the mill for $10 million and gave Maxim the money the day before they filed for bankruptcy. The answer is the court could require that they return that money. They could get that money back. But that's the day before bankruptcy, and it's obvious. Suppose 4 or 5 years ago, an extremely complex...
I think the battery just went out.
Oh, yeah?
So holler while we...
Suppose in the 4 years before bankruptcy, and in an extremely complex transaction, somehow some value was removed from the Palco. From Palco to Maxim. Well, the committees will look at that, and their financial advisors will look at that. And it may be possible to recover some of that money, but there's no assurance that that's the truth. And the longer it's gone back, you have statute of limitations, you have discovery issues, and I don't know anything that happened because I haven't investigated this. I'm a bankruptcy lawyer, not a Palco expert. But if the owners of this company took money out improperly, recently you can get it back. A long, long time ago, it's just like a statute of limitations on anything else. It may be gone. If Horowitz Maxim at some point sell Palco, are the current creditors reimbursed, or does Horowitz Maxim keep all the profits of the sale? They don't keep a dime of the sale until creditors are paid. That's the same question as the first one we had. What exactly happens when a company gets rid of debt without paying? Is that just when the court absolves it? Yes. The answer to that question is yes. Regardless of who did what to who, you wouldn't be in this mess if you didn't have financial trouble. Courts, and part of the principle of Chapter 11 is sometimes, and this is good, sometimes it's better to save a company and pay everybody that it owes 50 cents on the dollar and save the company and save the jobs and save the industry and just cancel some of the debt. And that's the way bankruptcy works. And if you're an individual bankrupt, that's how it should be. Say you're an individual and you had a medical problem or a divorce and you can't pay your bills and you got to file, your credit card's in $15,000, you have to file for bankruptcy. If you do it right and you have a good lawyer in the process,